Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to Aaron Knapp unplugged.com, my new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe, and share this with someone who needs the truth. We're building something real here. We're building something fearless, and we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Plug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no.
Hey there, good afternoon, Lorain County, Lorain City, and beyond. Sorry about the little bit of a delay there. I'm still kind of working on throwing together all of my information for this 4 o'clock podcast as I was trying to gather everything together into one big giant bundle before we went live. But unfortunately, I was unable to finish that. So, what we're going to do is we're going to move forward with what we have right now and just kind of wing the rest. Which usually goes okay for me because I feel like I'm pretty much winging almost everything anyway. Let me just double check something here though, real quick, because I believe I can kind of feed some of this stuff back in and get it all done. Well, what we're going to be talking about today a little bit is about oaths of office. That's right, folks. Oaths of office. Do they matter? Why they matter? How they matter? What you do with them? And why we're dealing with them. And, mainly we're talking about our clerk of the municipal courts. Our clerk of council, Brianna Dole, and our other clerk, Maggie Parton. And we get into whether or not they should have their oaths as provided by the Ohio Revised Code, statutory code, Lorain, Ohio's laws, the state's laws, and what the actual law department and other individuals seem to have thought-wise on this matter and where we're going with it in the future. I've concluded from my stories that I wrote that yes, she should have an actual oath of office, and I don't think it's as in the grand scheme of things as far as like punishment or something goes as big of a deal as everyone would like to think it is, or at least as maybe some of my constituents or friends or followers would think it is. It is a big deal. I mean, it is your oath of office. You are supposed to have one. Yes, it's constitutionally required. Yes, it's a big deal. But it's not like I feel like there's some giant gotcha moment here that somehow people are going to get charged with crimes over. It doesn't feel like that kind of a discussion, right? It feels like more of a, you guys kind of probably should have done this and you haven't, and we kind of need you to do it. And I feel like that's where we're at with all of this stuff right now. And that's kind of what this whole podcast is going to be about, is the oath of office and how things are supposed to be and how they are not here in the city of Lorain. And so I now have all of my documentation and ducks in a row to start this podcast appropriately. So we're going to start it out. The Oath, the Law, and the Clerk is the name of this podcast. Done by yours truly, Aaron Knapp, here at Unplugged. I want to thank you guys for tuning in today. Remember, journalism is not free. If you guys want to donate, right up here is my QR code. Scan that QR code, and feel free to donate to me to keep local journalism alive. Now we're going to set the stage today. Good afternoon. This is Aaron Knapp, as usual, and you're listening to Unplugged Live with Aaron Knapp. And today we're not discussing a rumor, and we're not doing personality-driven drama, right? We are doing the one thing government fears the most. The plain text of the law. We're going to cover the law. We're going to read it out loud in order and apply it to people who exercise power in the city of Lorain. This episode exists because a citizen, aka Karen Petty, who is also my reporter, has been asking some questions since last year about this on the record, in public, to the city of Lorain and in writing. You know, the question is not a petty question, even though it's from Petty. It's not a procedural nitpick. It's a structural demand for proof that the city is operating lawfully, which it seems to have a problem doing lately. It is the kind of question that should be answered immediately by producing a document that either exists or does not exist. And if the city cannot produce that document, then the absence is not a misunderstanding. It's a failure of the most basic prerequisite of holding office, right? Like what you're hearing tonight is the difference between, or today I should say, what a city says it's doing and what the Constitution of Ohio requires it to do before it ever touches any sort of public authority, right? This is the not an argument about whether you like an official or not. It's not even an argument about whether an official is competent or not. This is a threshold issue, right? It comes before all of that. You have to answer this question almost like standing in a civil suit. The question is whether the city has a lawful foundation under the Ohio Revised Code to allow an officer to exercise power at all. That's it. The oath is not ceremony. It's not some photo opportunity. It's not a tradition that we can or cannot follow or do away with. It is not a constitutional, it is actually what it is actually a constitutional gate. The oath is the legal moment where a person steps into office and binds themselves publicly to the constitutions that they are supposed to obey. You know, I swear to uphold and defend the Constitution of the United States of America against all enemies, foreign and domestic, so help me God. There's more to it than that. I'm not going to go through it all with you guys right now, but until that happens, the Constitution does not treat the individual as someone who has entered upon the discharge of duties of that office, right? And that phrase matters. It's important. It's not poetic language. It's not just something that we read in the Constitution and then forget about. It is a literal condition, right? It's a condition that is placed upon all public positions, and it is a before and after line, right? Boom. Tonight, or today, I should say, we're going to go into a spotlight on one office that's treated as if administrative and harmless, but in reality, it is one of the most important positions inside the legislative structure of a city. And that's the clerk of council. In this case, it's Brianna Dole and Maggie Parton. They're the official record keeper of the municipal legislature. The clerk is the custodian of the journal. The clerk certifies compliance. The clerk maintains the public trail that provides and proves what the government did, what it did, when it did it, whether it followed its own rules, and how those rules will follow. The clerk's hand is on the machinery of the law itself at all times. If the city has been operating, as the reporting and record disputes indicate, without a properly filled oath for the clerk of council for an extended period of time, that's through a couple of different council periods and all of that, then this stops being a debate about compliance culture, and it actually becomes a question about the lawful authority of the clerk and the city and the laws behind them. Now, this is where people get uncomfortable, right? Because that oath is not an internal policy. It's not a council rule. It's not it's not something they can just wave off, right? The council can just wave off, say, we don't want to do this anymore, like Rule 41. From now on, we just want to have Maggie and Brietta be our reps up at the city level as far as records go. And so they're going to take the Sunshine Law classes for us. And that kind of stuff, right? No. It is foundational. It's a foundational contract that makes the public power legitimate. As we walk through these layers, these 3 layers that no city can ever escape, first, the Ohio Constitution and what it commands, not suggests and not prefers, commands. Commands, demands, commands, orders, commands. Second, the Ohio Revised Code and the record keeping obligations that turn the oath into a producible public document. And then third, the City of Lorain's own codified ordinances, which openly admit in their own rules of interpretation that every ordinance is presumed to be enacted in compliance with the constitutions of the United States and Ohio. Now that matters because it means the city cannot read its own code in any in a way that it dodges constitutional requirements. And the public is often told that government is complicated. There are many layers. That it's like a bean dip, right? 7 layers. There are procedures, and that these are technical issues that are just meant for insiders. You regular folks, you wouldn't understand this. I mean, but the oath is the opposite of that, right? The oath is simple. It's binary. It either exists as a signed and filed record or it does not. Either a person took it before entering upon the duties of office or they didn't. Either the city can prove compliance or it cannot. Either they got to put their hand on that Bible or whatever they swear to and they said it. Blah, blah, blah. If you're a resident and you're at home listening to this, here's what I want you to understand before we go any further, right? That this isn't some abstract legal exercise, some thought process, right? This is the same office that records your votes, the votes of the city council, certifies ordinances, and controls the meeting notice process. It is also the office that the public relies upon to verify the legitimacy of what council does. That's important. Brandon's job is important. The public does not get transparency by being promised transparency. The public gets transparency when the legal prerequisites for government action are satisfied and documented, and when the records proving compliance are available for inspection. And that's what this whole episode's about. Not a fight, not a feud, not a personality clash. The foundation, the oath, the record, the proof, right? Because in constitutional government, authority is not assumed. It's demonstrated. And the law tells us exactly what that demonstration is supposed to look like. Exactly. And hold on. I gotta read what you guys were writing real quick. Let me get to the end of this and then I'll read what you wrote. That's what this episode is going to be about. Not a fight, not a feud, not a personality clash. The foundation, the oath, the record, the proof. Because in constitutional governments, which Lorain is, authority is not assumed. It's demonstrated, and the law tells us exactly what a demonstration is supposed to look like. So let me see what you wrote up here, because I can't see. Yep, 6. Ain't that the truth? So that brings us to part 1, the constitutional foundation. Before we move on, I'm going to play a quick sponsor ad only because I want to go grab another water bottle. So I'll be right back, and we're going to play a quick ad from a sponsor while I go ahead and grab that water bottle. So we'll just, since it's a city council day, we're going to play a quick ad to make sure everybody knows. And of course, it doesn't look like I updated my city council one. So we're going to pull this up real quick, and we're going to add this. We're gonna. Hey there, folks. Aaron here at Unplugged with Aaron Knapp. I want to give you a quick reminder for everyone watching that the City of Lorain holds its regular city council meetings on the first and third Monday of every month. And those meetings are not just for council members, they are for residents. If you care about what happens in your city, and if you speak or want to speak on an issue, ask a question, or simply be present and informed, showing up matters. Participation matters. Even sitting in the room and listening matters. You do not need to be an expert on any of this. You do not need permission to care. You do not need to do anything other than just show up. So check the agenda, folks. Mark your calendar. And if something affects your neighborhood, your family, or your future, take a seat, raise your hand, and make your voice part of the record. Lorain City Council, first and third Monday. Your city, your meetings. Those council meetings start at 6 p.m. Eastern Standard Time, and they're held inside of City Hall. Make sure you attend. this Monday's meeting. Hey there, folks. All right, back from getting the water. That brings us to the first section, constitutional foundations. Now, it's important to know before you ever get a statute or ever get to a statute, before you ever get to a city ordinance, right? Before you ever get anywhere in policy manuals or meeting rules or internal procedures, there's a simple requirement for an oath. It begins at the highest level of law that governs the state of Ohio. Hell, it begins all the way up to the president. Everyone takes an oath. Military, we all take oaths. It begins with the Constitution itself, and that matters because a city does not outrank a constitution. A council rule does not outrank the Constitution. An administrative practice does not outrank the Constitution. Every layer of government sits underneath the Constitution. You guys kind of getting where we're going with this? The Ohio Constitution states in plain, direct language that every person chosen or appointed to any office under the state before entering upon the discharge of their duties of that office shall take an oath or an affirmation to support the Constitution of the United States and the Constitution of the state of Ohio. That's not technical language. That's not ambiguous language. That is a command. It is a directive. And when constitutional language is that clear, courts don't reinterpret it, right? There's no question to figure out what it means. They enforce it as written. The phrase that controls everything here, you guys got to remember, is before entering upon the discharge of its duties. Okay? The phrase that controls everything here is before entering upon the discharge of its duties. Before entering upon the discharge of its duties. That phrase is the dividing line between lawful authority and unlawful exercise of power. It does not say after beginning work. It does not say at the first meeting. It does not say at the next available opportunity. It says before. Not after, before. That word has meaning. It is a condition precedent. In law, a condition precedent is something that must occur before legal authority exists to act. That wasn't legal advice. That was just me quoting the law. So when the Constitution uses that word, it is telling you that the oath is not part of the job. Right? It's the gateway to the job. It's the key to the lock. Right? It is the legal act that must occur before a person has authority to act under the office at all. To have the authority to act under the office at all. Until you're sworn in, until that happens, until you take the plunge and say, I do, sign on the dotted line like a marriage to the government, to the people, the individual is not someone who has lawfully entered upon the duties of their office. They may be physically present, right? They may be performing tasks, right? But the constitutional requirement that legitimizes that authority has never been satisfied, ever. And that's where the entire structure of the government either stands or falls. Listen, folks, the Constitution does not treat authority as something that automatically attaches to a title. It treats authority as something that is conditioned upon compliance, right? The oath is the act that transforms a person from a private individual into a public officer bound by constitutional obligations. Now, without that act, the transformation has not legally occurred. This is not symbolic language. The oath is not about a tradition, right? It's not about ceremony. It's not about optics. It's about a binding legal commitment that ties the office holder to the Constitution. It is a public declaration, folks, public declaration that the individual accepts the limits of their authority and agrees to operate within those specific limits. That is why the Constitution requires it before any duties are performed, because the obligation must exist before power is exercised. They have to be bound by the rules before they can exercise the authority. This is also where the issue becomes unavoidable in a real world sort of context, right? If a person is exercising the functions of an office, certifying records, maintaining the official journal, posting notices, or otherwise acting under color of law of that office or color of that office, the Constitution requires that we, the people, the citizens, be able to hold them to answer one simple question. Did the oath occur before the duties began? Not eventually, not at some point in time, before. And if that question can't be answered with a record, then the problem is not procedural, it's constitutional. Because the Constitution does not say the oath should exist somewhere, right? It requires that it occur as a prerequisite to authority itself. It requires that it occur as a prerequisite to authority itself. It requires that it occur as a prerequisite to authority itself. This is why the question that has been raised over a year matters. It's not about some personality dispute. It's not about politics. It's not about whether the constitutional foundation that allows government to act was satisfied before that action began, is what it's about, right? Because if that foundation is missing, then everything built on top of it is no longer just a question of compliance, folks. It becomes a question of lawful authority. Government does not get to skip the first step. And the Constitution makes clear what that friggin' first step is, right? I don't know. It just gets me riled up because this isn't a hard thing to do. I mean, simply they just bring her a Bible or have her say, "Do you swear, you'll support the Constitution of the United States of America?" So, yes, done. Walk away. Simple thing. I don't know why she's fighting so much. Why would you be scared of the Constitution? But once you leave the Constitution and step into the Ohio Revised Code, the law does not soften that requirement, right? It tightens it. The Constitution tells you what must happen. The statutes tell you exactly how it must be done, how it must be preserved, and how it must be proven. This is important because this is where the oath stops being a principle, right? An idea, and becomes the actual evidence of misdeed. The Ohio Revised Code section 3.24 makes it very clear that there is no barrier to compliance. There is no barrier to compliance. There is no barrier to compliance. Judges can administer an oath. Elected officials within their jurisdiction can administer an oath. Notaries public can administer an oath. The law does not allow an official to claim there was no one available. The law provides multiple lawful ways to complete the requirement. There is no excuse built in the statute. There isn't. Sorry. But the most important section of that whole law 3.24 is that is not who administers the oath, right? Because that doesn't really matter. It's just an administered oath. The statute requires that when the oath is certified in writing, it must be signed by the person taking the oath. It must be signed by the person administering it. It must include the date. It must include the title of the official administering it. And if a seal exists, that seal must be affixed. Simple stuff, right? Not optional language, because it's actually a checklist. And the reason that checklist exists is simple. The oath must be verifiable. It must exist as a document that can be produced, and it must exist in a form that allows anyone reviewing it to know who actually took the oath, right? Who administered the oath, when it occurred. The law is not interested in whether someone says it happened. The law requires proof. Well, then you move on to Ohio Revised Code 705.28. Well, that law becomes even more direct according to what I'm reading. It states that every municipal officer and every salaried employee shall take and subscribe to an oath before entering upon duties of the office, and the oath shall be filed and kept. The statute does not leave room for interpretation. It uses mandatory language. Shall take, shall subscribe, shall be filed, shall be kept. This is not guidance. That is a legal requirement. All right, folks. Here, we're going to do this one more time together, okay? I got an idea. Hold on. Since Garen, and we only got but a few viewers, Garen loves my my little act a little. We're gonna have a little fun with this one. Let's see, what was this guy's name again? I forget. I'm gonna have to look it up. It's been a hot minute since I've looked up his name. Lost everybody when I went to get my puppets. Well, I don't know. It's calling Frank. So hey, Frank, what do you think about this? Can you read this for me? It states that every municipal officer and every salaried employee shall take the subscribe to the oath before entering office upon the duties of the office, and the oath shall be filed and kept. The statute does not leave the room for interpretation. No. It says does not leave room. Oh, does not leave room. Does not leave room for interpretation. It uses mandatory language. Shall take, shall subscribe, shall be filed, and shall be kept. Ain't that nice? I feel like that's like me telling you what to do, right? Like that is not guidance. It's the legal requirement, right?
Yeah.
All right. So legally, I'm going to require you to take your ass back over there. Anyway, it's simple. A child's toy can figure it out, okay? Now let's tell you, this is where the consequences become more into focus, right? Because a statute uses mandatory language. The failure to comply is not a minor defect. It's a failure to satisfy a legal condition that is required before authority is ever exercised. The Constitution requires the oath before duties begin. The statute requires the oath to be signed, certified, filed, and kept. And when those things do not occur, the problem is not paperwork, right? The problem is that the legal foundation for exercising authority has been established in a way that the law requires. It has not been done or established in a way that the law requires. And this is where the question becomes unavoidable. If the law requires a signed, dated, filed oath, and that oath cannot be produced, and what does that mean for the authority exercised under that office? Well, the statute says that the oath shall be filed and kept. That's not about convenience. That's about accountability. That is about ensuring that when the public asks for proof, the government can produce it, right? Because the record does not exist. The law, if the record does not exist, the law does not say, that is acceptable, right? The law says that a record must exist. That's it. That brings us to something that cannot be ignored. This is not a hypothetical problem. This is a question that it appeared yesterday. This is something that's been raised on the record repeatedly over the course of the last year. Garen Petty has not been asking, for the oaths just once, not casually. We're talking repeatedly in meetings and communications in a way that puts the city on notice that this was a question that required a document, not an explanation. And instead of a document, what you see here is the record and internal discussions about how to handle the issue. You see communications that do not point to an oath, but instead point to uncertainty about what should be done. At one point, as reflected in communications involving council leadership, there's a request for guidance directed from the clerk, to the law clerk, Michelle Becco, asking how the issue was handled previously, where the answer was that stated that they didn't have to actually take the oath. And in substance, the question being asked was not where is the oath, but how did we deal with this last year? What did we answer this? Well, that distinction matters because the law does not ask how something was handled last year. The law asks where the oath is, where was it taken, whether it's signed, whether it was filed, whether it can be produced. The statute does not provide a substitute of institutional memory. It requires a record. And so when the response to a direct legal question is not the production of required documents, but a request for guidance on how the situation was previously addressed, well, that's not compliance. That's evidence that the system is not operating from a place of documented proof. It's operating from a place of internal handling. Well, if there were... Listen, that's where the problem becomes serious, folks. Like, because Ohio law doesn't require or doesn't allow, compliance to be based on how something was handled previously. It requires compliance to be proven on what exists. A signed, dated, filed oath of office. That the answer the law demands. That's exactly the answer the law demands. So the question remains as simple as it was when it was first asked. If the Constitution requires the oath before the duties begin, right? Before, not after. And the revised code, Ohio revised code, just, requires that oath to be signed and filed and kept. And where the fuck is it? Where's Brianna's oath? Where's Maggie's oath? Why is it all these other people have oaths? All law enforcement have oaths. A lot of the other, salaried employees have oaths. But, Garen pointed out even technically the legal department are all salaried employees. And as such, they should be considered for the oath. I feel like, the base next line is that, if all salaried employees are supposed to have oaths, then why don't they? Because we're a constitutional city. We're legally and mandated ethically to be constitutional. And, that brings us to our next section here, which is why this oath actually even matters. At this point, the question is no longer what the law says, right? The Constitution's already spoken. The statutes have reinforced it. The requirement is clear. So the next big question is the one that people are trying to minimize and the one that really matters the most, right? Why does this exist? Why does the law care whether an oath is taken, signed, filed before a person exercises any authority? Well, that answer is something we talk about here on this show a lot: accountability. But not in the abstract sense that gets used in public meetings, right? This is like literally legal accountability. The oath for all of these officials is the moment where they actually, a person actually who is about to exercise the power to wield the enormous power of your government. And, you know, that is enormous power at all levels. They're binding themselves to that constitution that limits their power, that we all agree should limit their power. It is the line between private action and public authority. It's the moment where the law requires a person to say, in a form that can be documented and proven, that they understand the limits of their authority and they agree to operate within those limits, right? And that's why the Constitution places the oath before the discharge of the duties. I mean, the oath, the oath, the oath is all that matters. Because without it, you have no framework, you have no laws to structure anything. Everything else is based off the oath, the Constitution. If the oath to the Constitution is no longer matters, then we're just in anarchy. Because the law does not trust power to regulate itself after it's already been exercised, folks. The obligation always has to come first. The commitment must exist before ever any authority is used. The oath is the condition that must be satisfied before any law recognizes that a person has entered into an office in any sort of a lawful way, right? And I feel like this isn't some sort of symbolic requirement. This is not about, some sort of old school, this is the tradition, this is how we've always done it. The oath is what creates the legal binding link between an individual and their constitution, both the Ohio and the United States Constitution. Without that link, the exercise of authority is no longer grounded in the condition that the Constitution requires. It becomes authority without prerequisite that gives it legitimacy under the law. That's it. And that's why the courts have treated the oath as a condition of office, not as an accessory to the office, not as something that can be corrected later, a condition, something that must exist for the office to be lawfully held in the first place. When the Constitution says before entering upon the duties, it is telling you that the oath is part of what makes the authority valid. It is not something that, can be layered on after the fact to try to fix a problem. And this is where the consequences become real, folks, because if the oath is missing, the question is not whether someone made a clerical mistake. The question is whether or not the authority being exercised ever met the constitutional conditions required for it to exist. And when the official certifies records, maintains the official journal, controls notice of meetings, or performs any act under color of office, the law assumes that the prerequisite conditions have been satisfied. One of those conditions is the oath. And if the condition is not satisfied, then every action taken under authority becomes subject to challenge. Now, that's not because someone disagrees with the decision, but because the legal foundation for making that decision may not have been established in a way that the law requires. That issue shifts from whether the decision was correct to whether the authority to make the decision existed in a lawful form at all. And that's why this is not a technicality. It's not a minor defect. It's not something that can be brushed aside and just, as paperwork or paperwork errors. Because the oath is the first act of lawful authority. It is the document that proves the person has accepted the obligations for the office before exercising any power. It is the record that ties every subsequent action back to the lawful foundation. And when the record cannot be produced, the problem is not theoretical, it is actually structural. Because the law does not allow the government to operate on assumptions. It requires proof, a signed oath, a dated oath, a filed oath, a record that can be produced when the public asks for it. So when the question is asked, where is the oath? That's not a rhetorical question. Rhetorical, Garen. That's the exact question that the law requires be answerable. Because in a constitutional system, authority is not presumed. It's not, presumed ever. It's actually demonstrated through its use. And the oath is the first piece of evidence that demonstrates that it exists. And the City of Lorain's own code even says it. When you bring the issue down from the Constitution, the Ohio Revised Code, to the local level, something more important happens. Right? The City of Lorain's own laws begin to confirm everything you've already heard. There is not a situation where local law creates an exception or softens the requirement. The city's own codified ordinance recognize the same structure, the same legal obligations, and the same constitutional framework that governs every other level of government. Chapter 101 of the codified ordinances is, it's not where people look. It's not where controversies are debated. It's not where policies are argued. It's the foundation, right? It tells you how to read and interpret the law. It tells you how to, figure out what's going on, and it tells you what is presumed when the city acts. And when you read it carefully, it does something that eliminates any argument that the city can operate on outside constitutional requirements, right? Section 101.02. It defines, clearly, terms that apply throughout the code. One of those terms is oath. And it states that the oath includes affirmation and swear includes affirm. That may sound simple, but it's legally significant. It means the city has incorporated the concept of an oath into its own legal framework. It recognizes it. It uses it. It relies on it. The oath is not something external to the system. It's actually part of the system. Then you go to the provision that controls everything else, 101.07. Determination of legislative intent and when the language is direct. It states that when the city enacts an ordinance, it is presumed that the ordinance, with the Constitution of the United States and the Constitution of the State of Ohio, is intended. It's not a suggestion. It's not a rule of interpretation. It means that every ordinance must read in a way that complies with the Constitution. I mean, we're talking about the gun law. It means you cannot interpret a local rule in a way that avoids a constitutional requirement, like the gun law. It means you cannot build a system that functions outside of the constitutional limits, like the gun law. The city's own code requires that compliance be assumed in every action taken, except for the gun law. And so when the constitutions require an oath before entering upon the duties of office, and the Ohio Revised Code requires that the oath be signed, filed, and kept in the city's own ordinances, do not create an exception. They require that those constitutional obligations be part of how the city operates. This is where the argument that just because, something is just local procedure collapses. Because the city itself has already said that its procedures must comply with the Constitution. And that's the rule the city adopted for itself. Once that rule's in place, there is no way to read the ordinances in a more, in a way that removes the oath requirement, so to speak. The court can't allow it or doesn't allow it. The Constitution does not allow it. The statutes don't allow it. The structure, it's consistent from the top to the bottom. All right, we're going to take a quick break here. I'm going to refill my coffee cup and get on to the part 5, which is the legislative structure of the city. I'm going to run a quick little ad, and then I will get right back to it. Thank you guys for staying tuned and for tuning in today to Unplugged with Aaron Knapp. Here at Unplugged with Aaron Knapp, we like to thank our sponsors. We have a few unofficial sponsors tonight, and they are definitely not paid sponsorships. I want to throw out there a big thank you to Joseph Jones and Eric Jones of the Lorain Daily and the Vermilion Daily. They have a local news page. You should check them out. They do plenty of great work, broadcasting all the news that is the news that you want to have in Lorain and Lorain County. So check them out. Also, please, if you need any legal services, feel free to reach out to Robert Gargas. You can find him listed online. He's a fine attorney and comes highly recommended by yours truly. And last but not least,
I want to mention DNC Radio. Please make sure you check out one of the up and coming internet hip hop stations and all of their shows. They put on a lot of shows. You have the Never Outdone show. You also have the Eric Bowen show, Speak Up, Speak Out. So please make sure you guys check them out as well if you're looking for your latest and up-to-date hip-hop artistry. Thank you for tuning in. This has been a non-paid sponsorship brought to you by Unplugged with Aaron Knapp. Hey there, folks. Aaron here at Unplugged with Aaron Knapp. I want to give you a quick reminder for everyone watching that the City of Lorain holds its regular City Council meetings on the first and third Monday of every month. And those meetings are not just for council members. They are for residents. If you care about what happens in your city, and if you speak or want to speak on an issue, ask a question, or simply be present and informed, showing up matters. Participation matters. Even sitting in the room and listening matters. You do not need to be an expert on any of this. You do not need permission to care. You do not need to do anything other than just show up. So check the agenda, folks. Mark your calendar. And if something affects your neighborhood, your family, or your future, take a seat, raise your hand, and make your voice part of the record. Lorain City Council, first and third Monday. Your city, your meetings. Those council meetings start at 6 p.m. Eastern Standard Time, and they're held inside of City Hall. Make sure you attend this Monday's meeting. Hey there, folks.
All right, sorry about that. I had to get some coffee. Starting to get a little way late in the day. You know those crashes. It's 444. All right, on to part 5, the legislative structure in our city. So, gotta sit up straight. Sorry. Now, when you look how our City of Lorain is structured, the ordinances, they lay out something very specific, right? It's not a list of employees. It's not a list of job titles. This is the formal structure of the municipal government. These are the offices through the public, which public authority is exercised, right? You got the legislative branch, council members at large members, ward representatives. These individuals, they enact the laws for you. And then you have the administrative branch. You got the mayor, the law director, the auditor, the treasurer, Ray Carry on, the safety service director. And these are the individuals who execute those laws. And within that structure, placed directly inside the legislative framework, we have Brianna Dole, the clerk of council, or Maggie Parton, depending on the day. Now, these two young women are very integral, important people when it comes to our government. Their placement matters. The clerks are not just a general employee. The clerk is listed, at least in Brianna's case, not as support staff. The clerk is embedded within the legislative structure itself. The clerk exists because the law says the clerk exists. Let that sink in. The clerk exists because the law says the clerk exists. So Brianna's job exists because the law says her job exists. That's no questions asked. We all agree on that. These are matters that no one should disagree with me on. Brianna is the clerk. We all agree that. Her job is very important. We all agree on that. We agree she's embedded in the structure. We agree her duties are defined by law, that her authority flows from the office and not from an employment relationship with the City of Lorain. She may get paid, but When you look closely at what the clerk actually does, the clerk maintains the official journal of all proceedings. The clerk records votes. The clerk preserves ordinances and resolutions. The clerk certifies official records. The clerk is responsible for the accuracy and the integrity of the legislative record itself. Honestly, Brianna's job is probably the most important job in all of the city when it comes to as far as within that legislative section, in my opinion. I know I give her crap on occasion. Well, Garen probably. But look, you guys are all public officials. You signed up for this. You make good money. I mean, look, I'll be honest. If you'd elected me, I would have taken the shit like gleefully. You know, if I had a position within the government was making $80,000, $90,000 a year, you guys shit on me all you want. I don't give a fuck, right? Like, you call me names, I will literally stand there and let you cuss me up one side, down the other, flip me off, all while I go to my ATM every month and be like, beep, 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 beep. Yes, baby, yes, whatever you want this month, sweetheart. No, we don't have to struggle. No clarity. No, we won't have to struggle. Oh, will we struggle? Well, I know Daddy went to college, but the chief of police. Yeah, I know you really want us to be able to shop and buy whatever. I know, but we can't because we can't get a job because the city of Lorain and the chief of police of Lorain are such pieces of shit bigots and assholes that they caused your daddy to no longer have. I know. Oh, wait. Yeah, I know. Well, I mean, I know the courts were supposed to end. Yeah, but the judges are idiots too. They believe them. Well, I know everyone can't be idiots. Well, apparently they can. I mean, I don't know what to do anymore. Well, listen, the bottom line is we're unemployable, babies. Daddy's working on that. But in the meantime, we get to starve and the city gets to thrive. So if you have complaints, that don't send them out because they'll just fuck you and literally and figuratively. So, hey, sorry, babe. You born into the wrong family. Your dad's a troublemaker. Oh, wait, I'm sorry. Was I having that conversation with you or my daughter? I don't know. I keep saying it out loud. I mean, everybody wants to talk shit about me and all this stuff. I mean, they want to say, oh, you're a whiner, you're crap. Fuck you. You know what? Sheriff Hall's bitch ass. I just posted all those messages the other day. I mean, like, literally, like, go look at the messages. I literally have a text message where he says, go check your email and look at what I wrote you. And when I go look at that time frame, it's that SF 400 letter that he sent to me. That personally he told me was sent to him by his lawyer, who is Nietzsche. So, I mean, again, you guys want to talk about, oh, but is he conflicted? Fuck yeah, he's conflicted. I get it. I thought I would get an impartial investigation, which I did not get. So, these official acts that the city of Lorain is doing are when an ordinance is passed, the clerk records it. When the vote is taken, the clerk, is the one that's documenting it. When a code is certified, that's the clerk's name. It's on the certification. It's not an administrative support role. That's governmental authority. Brianna wields authority, as she should. And this is where the constitutional requirement becomes unavoidable. The Constitution does not say that only elected officials must take the oath. It says every person chosen or appointed by or to any office must take an oath before entering upon the duties of that office. And I think I may have messed that up when I added by. So let me see. Okay, so it's not by. It's the Constitution does not say that only elected officials must take the oath. It says, this is what it says. Every person chosen or appointed to any office must take an oath before entering upon the duties of that office. And so when a position is created by law and by statute, I want to be clear here, and I'm sorry, sometimes I talk fast. When it carries defined duties, right? The legislature says you do this, 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 and this. When it exercises specific authority that affects the legal record of a government or of the government, then that position is an office, the office of the clerk. Now, not in a casual sense, not in this is my office and I am the clerk. No, in a very real legal matter sense. So the question is not whether the clerk performs important work. The question is whether the clerk, and she does, massively important work. Again, as I've said, Brianna Doe is one of the most important cogs in the wheel of the government because she is the clerk, which is so the reason why she should be sworn in to protect not only our government, but herself. Because when she's sworn in, then she's acting on behalf of the people, and everything she does is on behalf of the people. She's not sworn in, then they can easily just throw her under the bus anytime they want and say, well, she was never sworn in. She never acted legally. All of authority wasn't legal. We told her to get sworn in, but it's her responsibility, and she never got sworn in. Guess who gets to be the scapegoat for him, Brianna? You think it's going to be somebody else or you? Will it be Maggie or you? It's going to be one of you two. That's what they'll say in the end. You weren't sworn in. You're not indemnified. So the question is not whether the clerk performs that important work, right? It's whether the clerk occupies an office in the structure of municipal government. And based on the ordinances themselves, that answer is very freaking clear. The clerk of Lorain, the clerk of council, is part of the legislative structure. As they always talk about how important she is to the functioning of good government. The clerk is part of the legislative structure. The clerk is part of the legislative structure. I mean, I don't know what else to say. The clerk exercises authority that affects the law of the city. The clerk actions have legal effect. That's an office. And if it's an office, the constitutional requirement attaches, period. Pretty simple shit. The oath must be taken before the duties are performed. Not after, not eventually, but before. I've said this a few times. The structure of the city does not remove the requirement. It reinforces it. It places the clerk directly inside the framework of the government where the requirement applies. Period. That brings us to our next section, which is the role of our clerk. And once you understand where the clerk sits in that structure, you have to look at where the clerk actually does on a day-to-day basis, right? Besides have a bunch of different employees from the law department and dudes coming down there to sit all the time and chat her up. Once you understand the clerk sits in the structure, you'll feel it. The clerk of council is not an official record keeper for the legislative body, right? Just that, right? She is that. She is the official record keeper for the legislative body, but she is also, or the clerk would be also, they maintain the journal of proceedings. That journal is not optional, right? It's the official record of what actually happened and what the legislative body has done. It is what the public relies on to understand how and where and what decisions were made, how votes were cast, who voted on what actions were taken. The clerk preserves the ordinances. Oh my God. Hold on, Garen. Okay, well, yeah, maybe she should be bonded. I don't know. That means the clerk is responsible for maintaining the written law of the city. When an ordinance is passed, the clerk is part of the process. That ensures the ordinance is recorded, preserved, and available as part of the official code. The clerk also certifies documents. Certification is not a clerical act. It's not a ministerial act. Certification is a legal act. It is a legal representation of what the government is signing through. When the clerk certifies something, the clerk is stating that the documents are accurate and that it reflects the official action of the city. That certification carries weight. It is relied upon by courts, by agencies, and the public. Well, then let's roll over to Chapter 107. And again, I'm not claiming any of these things are look, I've done my research. I'm pretty sure that this is all factual, but it's not legal advice. This would be something that would need to be looked at by the Attorney General or by, somebody in the ethics department to give actual legal opinions on the matter. I'm not a lawyer. I'm not able to give legal opinions. I'm just going off of what current case law says when read and looked at thoroughly, and current ORC. So when you look at, Chapter 107, the clerk's role expands even further because the clerk is responsible for posting the notices of the meetings. The clerk must post notices of special meetings, including the time, place, and purpose, is what it states. I think to a T. The clerk must notify the media when requested, and the clerk must maintain records of those notices and notifications. By the way, I'm media. I'm sick of you guys not notifying me. That goes for LPD too. Start notifying me and Lorain daily. I got a business certificate on that wall that says I'm a media company. You guys need to get on it and stop being a-holes. The clerk must post notices of special meetings. Like I said, the clerk must maintain the records of those notices and notifications. It's not an administrative convenience. It's the mechanism by which the public is informed, and journalists are informed, and everyone's informed. That's how the city complies with the Ohio Revised Code 121.22.
I'm in the middle of a podcast right now. What's up? All right. So the Open Meetings Act, the clerk is at the center of the process, right? That's how the city complies. All right, sorry. Ohio Revised Code 121.22. That's the Open Meetings Act. The clerk is at the center of that process. And not only is she at the center, but they've apparently voted again to make her go to all the classes on behalf of the council. So now she has to know all of the sunshine laws, and she has to correct council every time they do something wrong, since she's now the keeper of the sunshine laws. So when she sees people texting or messaging on the videos, it's her responsibility to correct them, not theirs, because they allowed her to she allowed herself to be used to be their representative. So she is held responsible for every member of council's actions, regardless if they violate the Open Meetings Act moving forward, because she'll be the only one at that. That is also why she's at the center of that process. And there's a provision that elevates the clerk's authority even more. The code that states that the certificate by the clerk as to compliance with the notice requirements is conclusive upon the city and the municipal body. The code states that a certificate by the clerk as to compliance with notice requirements is conclusive upon the city and the municipal body. One more time. The code states that the certificate by the clerk as to compliance with notice requirements is conclusive upon the city and the municipal body. If you don't know what that means, look it up. But I'm going to tell you what it really means is it's legal notice that it matters, and that word specifically matters. It's called conclusive. It means that when the clerk certifies that notice was given, the system treats that certification as final. It's relied upon. It's accepted. It's not the subject to internal dispute within the structure of the city. The clerk's statement becomes the city's position. It's not some minor role. That's not some backbeat admin position. That's a position of authority. That directly affects whether the city is considered to have complied with statutory law. And that's where everything comes together, folks. You have a position that's created by law in the clerk of the council, placed within the legislative structure. I mean, it's literally on the laws in the front, certified by. Tasked with maintaining not only, the official record, but responsible for ensuring compliance with public notice requirements, and empowered to certify that compliance in a way that is treated as conclusive. That's not clerical. That's not minstrel. That is exercise of governmental authority. And under the Constitution of Ohio and the United States, and under the Revised Code of Ohio, a person cannot enter upon the duties of an office and exercise that authority unless they have taken the oath required by law. Again, a person cannot enter upon the duties of an office and exercise that authority unless they have first taken the oath required by law. So the requirement is not abstract. It is directly tied to the functions being performed. If the clerk is exercising authority, certifying compliance, and maintaining a legal record and acting under color of office, then the Constitution requires that the oath exists before those duties were performed. Not eventually, not retroactively, before. And because the statutes require that oath be signed, filed, and kept, that means that there must be a record. See how I keep repeating this like a broken record? There must be a record. There must be a record. Put the needle on the record. Put the needle on the record. Put the needle on the record. When the drum beats go like this, a record can be produced, folks. A record that answers the question the law requires to be answerable. Where is the oath? I want the knife and I want the oath. Open meetings last. So once you move into the Open Meetings Act, you're no longer dealing with internal policy anymore. You're dealing with one of the core transparency laws of the state of Ohio. Ohio Revised Code 121.22 is not operational guidance, folks. It is not. It's the lifeblood that I live by. It's the statutory mandate that governs how public bodies conduct their business. It requires that the official action be taken openly. It requires that deliberations occur in meetings that the public can attend. It requires that those meetings be public at all times, not occasionally, not once in a while, but all times. Say it with me, folks, all times. And the law does not say that government should try to be transparent, right? It requires it to be transparent. And it does not define transparency in vague terms. It defines them in practical ones. Meetings must be accessible. The public must be able to attend. The public must be able to observe.
The public must be able to know when those meetings are happening and what is going to be discussed. That's what and where Chapter 107 of the Lorain Codified Ordinances starts to come into play. The city did not create its own independent system, right? It adopted the rules of the Ohio Revised Code Section 121.22. And in doing so, the city tells you exactly where those rules are supposed to accomplish. The chapter states that its purpose is to establish a reasonable method for any person to determine the time and place of meetings and the purpose of special meetings. The language matters because it makes the standard clear. The goal is not simply to hold a meeting somewhere. The goal is to ensure that the person can determine when it's happening, where it's happening, and what will be discussed. It's not theoretical transparency. That's functional transparency, and it's designed so that the members of the public can actually act on the information. If the public cannot find the meeting, cannot understand what will be discussed, or cannot attend, then the purpose of the law has not been satisfied. That brings Miss Brianna, our clerk of council, directly into the center of the Open Meetings Act. Not only because she's the one responsible for taking all the classes for all of your Yahoo elected officials now, because they're too lazy to do it on their own, but because the clerk is the one responsible for posting the notice, maintaining the records, and certifying the compliance with these options. The clerk is the mechanism through which the city either meets its legal obligations or fails to meet it. That's not meant to be legal advice. That's just facts. So when you talk about the open meetings, you're not talking about abstract rights, right? I've taken the classes multiple times. You're talking about a system that depends on accurate records, proper notice, and lawful execution of duties, or at least I do. And those duties are being carried out under the authority of an office that the Constitution requires to be supported by an oath beforehand. Take your fucking oath. Jesus Christ, I took one. Why are you so scared of taking an oath? Why wouldn't you want to take an oath and swear to defend the Constitution of the United States of America and defend our laws against all enemies, foreign and domestic? I don't know, whatever. Guess you just want to be a traitor? Un-American? You just don't care? The definition of what counts as a meeting, though, there's many of those issues. Because the law doesn't limit itself to formal sessions, official votes, or meetings labeled as council meetings. The city's own code defines meetings as prearranged discussion of public business by a majority of members of a municipal body. That definition is critical because it removes the ability to avoid the law by changing labels. It does not matter whether the gathering is called. It doesn't matter whether there's a formal agenda. It doesn't matter whether a vote is scheduled. If a majority of members are discussing public business in a prearranged way, the law defines that as a meeting. And once it's a meeting, the ORC 121.22 applies. The meeting must be open. The public must be able to attend, and notice must be given. Requirements do not disappear because the discussion is informal. The law does not recognize that distinction. Morningside, right? Listen to me, Morningside. The law does not recognize that distinction. This is where the violations often occur. Not in the meetings that are clearly labeled and scheduled, but in the discussions that are treated as something less. Work sessions, informal gatherings, or coordinated discussions that can fall within the definition of a meeting if the elements are present, like 3 members of a body present, at Morningside, listen to me. Like the elements are present. The law does not allow a public body to avoid transparency by redefining what it's doing. So the question is not what a gathering is called. The question is whether the elements of the meeting exist. If they do, the law applies. We talked about notice is not formality. It's the mechanism that makes transparency possible. And without notice, the right to attend a meeting is meaningless because the public does not know when or where the meeting will occur. 107.04 of the city code requires that at least 24 hours meetings are given before a special notice, and the clerk must post that time and place and purpose of the meeting. The last requirement is the one that carries the most weight, right? The purpose must be stated. That requirement is not decorative. It exists so the members of the public will make an informed decision. If the notice says only that a meeting will occur, but does not say what will be discussed, the public cannot meaningfully decide whether to attend or not. The law recognizes that, and that's why the purpose is required. Section 107.05 goes further. It recognizes that the media has a role in public oversight. That if a media organization, like I just did a minute ago, requests notice, the city must provide advance notice on special meetings. That's not discretionary. It is a requirement.
The media acts as a conduit between the government and the public. Without notice, that function cannot operate. As I've told you guys multiple times, I put you on notice. I am the media. I want notice of these meetings sent to me. I want notice of everything sent to me. The code also requires that the clerk maintain records of notice and notifications. That is where accountability comes into play. Those records are not internal documents. They're public records. They can be requested. They can be reviewed. They can be compared to what actually occurred. That means compliance will never be hidden, and it'll always be subject to verification. The law is structured so that the public can test whether the requirements were actually met, man. Or folks, man. There's some flexibility to all of this, but there's limits. At the same time, the code introduces provisions that will allow for some flexibility. It allows for general descriptions of purpose. It allows for emergency meetings to occur without standard notice requirements. It states that the reasonable attempt at notification will constitute compliance. It provides that the clerk's certification of compliance is conclusive. Each of these provisions has a purpose. Emergencies do occur. Notice cannot be always perfect. Systems require some level of flexibility to function, but those provisions also create risk. When flexibility is applied too broadly, it can begin to erode the transparency the law is designed to protect. The phrase reasonable attempt is one of the most important examples. The law does not require proof that notice was received. It requires a reasonable attempt to provide notice. That lowers the threshold for compliance. It creates space for interpretation that the standard depends on how it was applied in practice. Well, there's a provision that the clerk's certification is conclusive. That concentrates authority in a single office. When the clerk certifies compliance, the system treats that certification as final. And that's important, folks. Hear that. When the clerk certifies compliance, the system treats that certification as final. Lastly, when the clerk certifies compliance, the system treats that certification as final. Now, that places a significant amount of responsibility on the clerk to ensure that the certification is accurate and supported by actual compliance. So you have a system that requires transparency, but also allows flexibility on how it's delivered. And that's going to create a little tension. The law promises access, but it also allows discretion in how that promise is fulfilled. And that's going to lead to a simple but critical question. Is the system being used to inform the public, or is it being used to create the appearance that the public was informed? Those two aren't the same things. Now, when you try to connect the oath back to the system, it all comes back to the oath requirement. The issue becomes direct and unavoidable. Clerk of council was not a passive participant in this system. The clerk is the one who posts the notices online and the notices in general. The clerk is the one who maintains the record. The clerk is the one who certifies compliance, and the clerk is the one whose certification is treated as conclusive. These are exercises of authority. Authority.
Have authority?
You will respect my authority. I am the clerk of council. They are acts that carry legal weight, right? They are acts that determine whether the city has complied with the Ohio law and the Ohio Revised Code and the Constitution. And under the Constitution and the Revised Code, the authority cannot be exercised unless the person holding the office has taken an oath before entering upon those duties. Not after, not eventually, not during, before. The law requires that oath to be signed. It requires the oath to be dated. It requires the oath to be filed and kept. It requires that a record exists. So when the clerk certifies compliance with the Open Meetings Act, the law assumes that the clerk has lawfully entered upon that duty of the office. It assumes that the constitutional requirement has been satisfied. It assumes that the statutory requirement of the document to retain the oath has been met. And if that assumption is not supported by a record, then the issue is not about whether a meeting was properly noticed. The issue is about whether the authority used to certify the notice existed in a lawful form. That brings the question right back to its simple form. Was the oath taken, and is it documented, and can it be produced? And that's where we get this breakdown. When you step back and look at the entire structure, the system's clear. The law requires notice. It requires access. It requires record keeping. It requires the meetings be conducted openly. It requires that the public be able to determine when meetings occur and when they'll be discussed. At the same time, the system allows flexibility. It allows general descriptions. It allows emergency exceptions. It allows reasonable attempts instead of guaranteed notice. It allows certification to be treated as conclusive. So two operating systems, and one promises transparency and the other allows discretion, and that's how it's delivered. The problem is that not they both exist. The law created both of them. The problem arises when discretion replaces compliance, when flexibility becomes the default instead of the exception, and when certification replaces verification, because the law is not satisfied by the appearance of compliance. It wants it. It actually requires this. The requirement is actual compliance, right? Not half-ass, not sorta, not occasionally, but actual compliance. And that's where the breakdown occurs. And not on what the law says, but on how it's applied. So finally on this, before I go to tonight's council meeting here, Shirley, I'm just going to say the law is not complicated. The Constitution requires that the oath be taken before the authority is exercised. The revised code requires the oath be signed, filed, and kept as a record. The city's own ordinance require that everything it does be interpreted in compliance with those constitutional requirements. The clerk of council is not a minor role. As I pointed out, it's an important role. It's a position that sits at the center of legislative process. It's not, it's the office that records what the government does, certifies, compliance-wise, and provides the public with access to information. That authority is not self-executing. It depends on compliance with the law. This is not about personalities. It's about political disagreements, Democrat, Republican, or otherwise. It's about whether someone intended. It's not even about whether someone intended to comply, right? It's about whether the structure that exists on paper is being followed in practice. Because when a government writes rules about transparency, you do not judge those rules by what they say. You judge them by how they are used. Compliance on paper is never going to be the same thing as transparency in practice, folks. And the law requires more than a system that can say it complied. It requires a system that actually proves it. And that proof starts at the very beginning, folks, with the oath of office. You take that Bible. I swear to uphold the Constitution of the United States of America against all enemies, foreign and domestic. So help me God. I know there's more than that, but again, we're at the end of our podcast and I gotta go. But that's the simple fact, folks. Either she took the oath or she didn't. And if she didn't take the oath, then she's not authorized to be acting under any sort of official authority. Now, I will say, it's been asked of me, and I'm going to bring up this question before I take off. There's been talk about, well, does that invalidate stuff? And you got to look back at my analysis on Antonio Baez and him holding office illegally. It seems to be a problem with Lorain not understanding how authority works. But in the grand scheme of things, no, it's grandfathered in. Like we assumed, I always forget the title of it every single time I roll in, but I have it listed out. There's a word for this. And basically, we assumed that they held the power. And since they held the power like, He-Man did in Grayskull, they're able to exercise the authority based on that. They're like, grandfathered in, but they still could be in trouble for what they've done. I wouldn't see that this would be a criminal issue for Brianna because, again, she's being advised by others as well. Although the Constitution does make it very clear that it's her responsibility to take her oath and make sure she gets it, not someone else's. That being said, we could argue, and she could argue, that she is not being given the proper information. And any one of those law enforcement or legal people or any of the people within the government apparatus that have oaths that can issue oaths could just easily, Ted Kalo, anyone could go down and just issue her an oath. It's a simple task. And by doing so, it protects her, us, and the city. Just keep that in mind, folks. Like, I didn't get right on this for Garen because it wasn't that big of a deal to me. To be honest, it still is to him, and I get it, and rightfully so. It is a big deal. But considering how many times I've taken a brick to the face for this city and this county over dumb shit, this is the least of my worries. But I am going to ask about it at tonight's council meeting, as should all of you, because it is the law and it is the oath that needs to be taken. So thank you guys for tuning in tonight. I appreciate you. Remember, if you want to donate, right up here is the little code. You can donate, keep journalism free and alive. And otherwise, thank you for tuning in today. This has been Aaron Knapp. We're here at Aaron Knapp Unplugged. Thanks for tuning in, and we'll see you guys next time.
Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask.